Oh.
Вибачте, будь ласка, мене не чули. I'm sorry, I have to repeat again because I have I was muted. Sorry, I was opening the event.
Yes,
but
thank you.
Did you hear me, those who are online? You didn't, so I will repeat it again.
Of course.
So, dear Rector Larissa Ditkovska and dear Dean Volodymyr Venher, dear participants of the round table, dear guests, dear colleagues, dear students who are with us here and online. Our event today is organized by the Center for Genocide and Human Rights Studies of the National University of Kyiv-Mohyla Academy and by the Ukrainian Free University. It is my great pleasure and honor to invite for welcoming address Rector of the Ukrainian Free University, Professor Larissa Ditkovska.
Which is the most important, that all successful things in any tales can realize only from the sad attempt. It means the two of them we have. And the sad attempt will be our victory, I hope.
Yeah.
The victory of our motherland. And now is informal and formal part of our meeting. First of all, I want to thanks to all of presence, to all our guests, and what is most important, to all the friends of Ukraine. Because only together, only with efforts each of us, we can have these successful results and we can have this victory, not only for our country, but for the whole world, for the democratic values, for the independence, for the freedom and main moral values during all the history of human being. And because of that, I want to warmly welcome to our round table dedicated to one of the most painful and critical issues of our time, the international crimes committed to the Russian Federation during its aggression against Ukraine, in the context of the Rome Statute of the International Criminal Court. We know that it is main idea not only to punish the aggressor, not only to have our victory, but to realize these main values of justice as the highest level of victory over the evil. For our university, and we know our history, it is more than 100 years, and it is a history of fighting against any aggressors, against any, not only the abuse, not only the trying to destroy our country and our nation and so on, but against the same values, as I said, of the whole world, because it is the values of very, very unique things, but the most moral things. Values of independence, values of autonomy, values of sovereignty, and it is simply the values of democracy at all. Now, we want to thank each of you who present here in Munich or joining us online for your dedicated to this human rights, for your dedicated to this professional work for our Ukrainian victory. My special gratitude to our moderator, Professor Dr. Miroslava Antonovich, as well as to our partner from the National University of Kyiv-Mohyla Academy. I wish all of you a productive and successful discussion as we seek concrete solutions that will bring Ukraine closer to justice. Glory to Ukraine. Slava Ukraini. Now you turn.
Thank you very much, Rector Ditkovska, and it is my great honor and pleasure to invite for welcoming address the Dean of the Law School of the National University of Kyiv-Mohyla Academy, Dr. Volodymyr Venher.
Greetings, I hope you can hear me.
We
Can
do.
you hear me? Yeah, perfect. So, dear colleagues, first of all, big thank you for both organizers, for Professor Antonovich and for representatives of Free Ukrainian University from Munich. It's really great honor for us to have this event, but on the other hand, it's a high level of urgency not to stay silent, not to ignore the relevant challenges, not to waste our time in our strengths and fight against aggressor. Taking Russia to accountability, doing proper investigation of all war crimes and other crimes committed during aggression of Russia Federation since 2014, it's a key precondition for free, democratic, and independent Ukraine. Very often we can hear from different politicians, from different, let's say, actors, that this boring legal routine, doing investigation, collecting all evidence, proving all the acts committed by Russians in Ukraine, it's something weird, and we should think about that only after Ukraine's victory. As a lawyer, I do not agree with that. We should work hardly right now. We should fix, we should collect all the data, all the facts, all the positions, all the speeches to have enough material to assess and to have all perpetrators and all criminals from Russian side responsible. This conference is not just scientific discussion. It's not just an opportunity to present results of individual or collective research activities, because all the panelists are really well respected in this or other fields of legal research. It's also a huge act of solidarity, because right now, having people abroad, moreover, having people who are visiting Ukraine, visiting Kyiv, participating in different activities in person in Kyiv, it's really great act of solidarity. I wish next conference on that issues and relevant issues will take place in our premises in Kyiv, and we will be happy to host all of you in Free Ukrainian Kyiv directly after Ukraine's victory. But right now, before that time, understanding all the obstacles, all the personal situations of all participants, we are really happy, we are really thankful for the Free Ukrainian University in Munich hosting this event and this opportunity not to be silent, not to be passive, but do our small but important legal input in developing tools to punish aggressor and to reach justice for Ukrainian people and for Europe. Thank you so much, and I wish you productive discussion. And again, I hope next time we will meet all together in Kyiv. Thank you.
Thank you very much. Thank you very much, Dean Dr. Volodymyr Venher. So today we will discuss the issues of international crimes which Russian political and military leaders, as well as Russian ordinary militaries, have been committing every day since 2014, with culmination after 24th February 2022. Our roundtable is in Munich, which I think to some extent is symbolic, and not because it was heavily bombed, damaged during Second World War, which we know was due to Allied bombing raid, but because Munich has been extensively rebuilt after Second World War and is now a major European city. Munich is famous for its historic reconstruction after Second World War. We certainly dream about times when Ukrainian cities such as Kharkiv, Zaporizhia, Kherson, and many other cities and small villages, small towns and villages, which are being destroyed by Russian aggressors every day for more than 3 years, will be rebuilt after Russia's defeat. Our esteemed participants today will speak on some of the crimes which are being committed in Ukraine, including the crime of genocide, sexual violence crimes committed in the course of Russian aggression against Ukraine, the destruction of cultural heritage, environmental destruction, with the accent on issues of accountability for them in national courts and in the International Court, Criminal Court. And now we turn to our topic, and I will suggest the following format. First, we listen to up to 15-minute presentations of our esteemed presenters, speakers. And in case there are short questions, either from here or online to speakers immediately after their presentation, you are welcome. Otherwise, there will be opportunity at the end of all speakers' presentations to ask questions and to discuss, to comment on the presentations. And I will kindly ask those who ask questions to limit the questions to 3 minutes and comments to 5 minutes. At the end of our discussion today, the presenters will have a couple of minutes for concluding observations. So let us start. Our first speaker today is Dr. Dmytro Koval. And let me say a few words about Dr. Koval. You saw it in the program, but I will repeat. Dr. Koval holds a PhD in international law. He served as a member of the Ministry of Justice Expert Committee on International Humanitarian Law and International Human Rights Law. Issues in Armenia, Azerbaijan, Belarus, China, Georgia, Kazakhstan, Tajikistan, and Ukraine. He also advised the Council of Europe, the European Parliament, UNESCO, the Ukrainian Ministry for Foreign Affairs, the Ministry of Culture, and the Prosecutor General's Office on different aspects of international law. He is a member of the board of the 2022 Nobel Peace Prize winner Center for Civil Liberties. He was a Fulbright scholar in the United States in 2019-2020 in Stanford University. And last but not least, last month, Dr. Koval was elected Chair of International and European Law Department of the National University of Kyiv-Mohyla Academy. The topic of presentation by Dr. Koval is Sustainable Peace in Ukraine and Accountability for the Crime of Genocide. So the floor is yours, Dr. Koval.
Thank you so much, Dr. Antonovich. And hello, everyone. I'm glad that this uneasy topic collected you all in this room and online. And I hope that we'll have a fruitful discussion today, interesting presentation, fruitful discussion afterwards. So let me start probably with a disclaimer. I won't be talking too much about the accountability itself or the facts that give us reason grounds to believe that Russian representatives, be it political representatives or military representatives, commit the crime of genocide in Ukraine. I will rather concentrate on other, some can say, geopolitical issues related to the crime of genocide. And that geopolitical issue may be formulated exactly as the topic of my intervention sounds. So it's the issue of sustainable peace through the lens of the obligations of states under the Convention Against Genocide. So with this disclaimer, I would like to start saying that it's well established in the international law that when the international crimes are being committed by some members of either state forces or paramilitary forces, the amnesty laws that are being enacted after the hostilities or atrocities can't grant the blatant amnesty for all those who perpetrators in some way in the commission of the crime of genocide. Any international crime actually, but my focus would be on the crime of genocide. When we talk about the Convention Against Genocide, there are at least a couple of articles that address this issue of amnesties, rather that implicitly suggest that amnesties are not possible in case of peace efforts, in case of any actually processes that follow the atrocities happening in the country. This instructs us about one very important thing, that whatever peace talks might be happening either now or in some distant future, these talks will be illegitimate in some respect if they do not take this axiom into the account. This rule into account that the blatant amnesties are against international law, against the convention and the practice that was elaborated by the international criminal courts and tribunals. So to expand on my initial citation of the convention, I would say that the practice of international courts support this idea that the peace agreements can't grant blatant amnesties. This issue was addressed by the ICTY, for instance, in a little bit different context. So ICTY didn't comment on the Convention Against Genocide. It rather said that in cases of tortures, commission of the crime of torture, be it a war crime of torture or crimes against humanity in a form of torture, the amnesties that follow the conflict can't guarantee the peace deals or peace agreements that follow the atrocities can't guarantee the blatant amnesties to all those who participated in some way in the commission of the crime of torture. But this conclusion formulated by the ICTY basically instruct us not only about the crime of torture itself, but also about any other international crimes, because in the wording of the decision, the crime of torture is mentioned together with the phrase preemptory norms of international law. So whenever the preemptory norms of international law are violated, for instance, the norm that prohibits torture, then there is the demand or the rule of international law that basically says that we can't guarantee amnesties to everyone, even if they participate in the commission of international crimes. So apart from this decision of ICTY in case of Antov Rungia, there is another decision of the International Court, or rather hybrid court, that is important in this discussion, and that's the decision of the Special Court of Sierra Leone. In the case of Charles Taylor, Sierra Leone Special Court had to deal with the issue of amnesties also, and these amnesties were granted by the so-called Lome Agreement that attempted to end hostilities in Sierra Leone between Sierra Leone state forces, but also different paramilitary forces taking part in non-international armed conflict in Sierra Leone. And this Lome agreement actually tried to suggest that peace trumps justice, and peace is more important than justice. And therefore, it proposed to give amnesties to even those people who participated in the commission of international crimes in Sierra Leone. But Special Court for Sierra Leone said that such a provision in the peace treaty violates international law, and therefore this treaty can't be taken into account when the issues of accountability are at stake and are being decided on. Therefore, even with the existence of Lome agreement, the court basically found a way to circumvent this agreement and still adjudicate cases of mass atrocities that were committed in Sierra Leone. Apart from these sources, conventions, and rulings of international courts, there is another body of law, soft law rather, that instruct us about the impossibility or rather unsustainability of any peace that disregards the issues of justice. And this source is the studies of the scholarship, but also the resolutions of the United Nations General Assembly, for instance, on the matters of transitional justice. So in these types of sources, transitional justice is discussed from various angles, one of which would be, of course, the peace, securing of peace in the post-conflict context, but the other would be justice and accountability for international crimes. In numerous reports, either the reports of a special rapporteur on transitional justice, the proper name would be on the promotion of truth, justice, reparation, and guarantees of non-recurrence, and also on the follow-up reports and resolutions. The either rapporteur itself, him or herself, or United Nations General Assembly reflected on the issue of this interconnection between justice and peace, and said that there's no short way or crosscut that would that would allow to disregard justice, and at the same time that would guarantee peace, sustainable peace, and non-recurrence. So basically, the rapporteurs and also United Nations General Assembly agreed that even if there is an attempt to somehow circumvent the issue of justice and come straight to the issue of peace without dealing with justice demand of the victims or survivors of atrocity crimes, in those cases, we will rather face with the freezing of the conflict than the actual dealing with the conflict and achieving sustainable peace. So all those materials on transitional justice that were taken into consideration by the UN General Assembly, but also by the rapporteur on transitional justice, inform us that the studies held on this issue and also the official positions of most of the states on the matters of transitional justice stands on this point that peace is only achievable if justice is also justice demands or justice consideration are also taken care of and they are taken into account. This line of argumentation goes even further, and it basically said that whenever we have the situation in which states or even a regional organization try to secure peace without addressing the accountability issue, the United Nations bodies should not endorse such peace agreements. So if, for instance, as it was discussed just recently, the United States of America or any other actor or state or international organization suggests to Ukraine and Russia to sign a peace treaty or peace deal, as it was called, that states that accountability doesn't matter, or that put peace above accountability and justice. The UN, the United Nations, should not endorse such treaties and should not basically seriously consider these treaties as legally binding, at least in part of the amnesties and ignoring of accountability. So that means that even if there is a situation of some peace agreement that omits clearly mentioning, clearly addressing the accountability aspect of peace, then the United Nations can't actually endorse or through its bodies support the implementation of treaties like these ones. And I think that that's quite important for many reasons. From the liberal international relation theory standpoint, it's important because it shows us, or reminds us rather, that indeed the sustainable, stable peace is achievable only if we also address some of the grievances of the societies that were in conflict and some of the demands of those societies. And if those demands have the distinct and obvious accountability component, then this aspect of accountability should be also addressed in the peace treaty. But from the realist international relations standpoint, the mentioned theories and mentioned legal arguments also matter, because they again remind us that that existing international law proposes a number of leeways, a number of avenues for victims, for instance, to seek justice, even in cases if, for the sake of some real politic considerations or realpolitik dealings, the states decide to ignore the accountability for atrocity crimes. So whenever there is the leeway, there is the option for survivors to seek justice either through international mechanism, such as International Criminal Court, or through domestic means, such as Ukrainian domestic jurisdiction or universal jurisdiction avenues. The survivors, through these actions, can undermine the peace agreements arranged by states, if those peace agreements ignore the justice aspect of peace. So I think that this brings us to an important understanding that even in the current world, the world where the interests of big states become more important than interests of individuals and interests of smaller states. And in the world of pragmatic international relations that quite obviously ignore some of the aspects of human rights law or other bodies of international law, the justice layer of any peace agreement should still be should still play a role in the discussions, and should still remind the participants of such discussions that even without the willing, quite a lot of stakeholders will have the options to undermine the peace efforts if the accountability issue is not addressed properly. With this, I would end and maybe add only one quick point that I probably had to make in the very beginning of my presentation, but it's still worth mentioning it. The fact that I ignored completely the factual side of the story, meaning that genocide was indeed committed in Ukraine, does not suggest that I believe that it's already proven thesis that genocide indeed took place in Ukraine. There are numerous indications that genocide happened and it was committed by certain Russian individuals. However, if we speak about the criminal procedure and the trustful education of cases, or rather the adjudication of cases that would be taken seriously by international observers, we definitely should not consider as proven the fact of genocide in Ukraine. And I would just briefly mention three main challenges that prevent us from stating without any doubts that genocide as a crime was committed in Ukraine. The first important challenge is the lack of a clear strategy on the side of Ukrainian prosecutors and investigators on how to frame genocide crime in Ukraine. Whether the approach should be taken that genocide was happening all around Ukraine, and therefore Russian forces, through such measures as, for instance, attack of Ukrainian critical infrastructure, including energy infrastructure, committed genocide. Or maybe the strategy should be that Russia committed genocide in particular locations that were under the Russian control, basically were occupied by Russia, such locations as, for instance, Mariupol, Bucha, or Izium. Or the strategy should be that Russia committed genocide only against certain categories of Ukrainian population, for instance, against children, by deporting them to Russia, adopting them in Russia, and then non-returning them to Ukraine or to the occupied territory to which they belonged. So the issue, the question, the challenge of strategy or lack of thereof is one of the most important when we speak about the accountability for the crime of genocide. Another challenge would be the challenge of the modes of liability. So in the practice of international law, it's not clarified enough what type of intent should be proven when we speak about the aiders and abettors of the crime of genocide. Different courts, international and domestic, approach this issue differently. Some suggested that all perpetrators and aiders and abettors of the crime of genocide should possess the genocidal intent. In other words, that they should want to destroy in full or in part national or ethnic group. Others suggest that the aiders and abettors may know about the existence of genocidal intent on the side of direct perpetrators, but they not necessarily should share this intent, and their participation in the hostilities may have different explanations. For instance, they may participate in the hostilities or in the atrocities because of the desire to, I don't know, get some promotion on their service, or some other reasons may guide their participation. Anyhow, that's another challenge, because this challenge will or rather overcoming this challenge would allow us to somehow delineate or somehow compartmentalize those who initiated genocide and actually organized genocide and in Ukraine, and also those who were just the tools of committing genocide in Ukraine. And last but not least, a third challenge is that crime of genocide in Ukraine is very hard to understand crime of genocide in Ukraine without using the post-colonial lens. And I think that this optics of post-colonial optics was not very frequently used in previous incidents of genocide. In Rwanda, the colonial past of Rwanda was studied to emphasize how the grievances between Tutsi and Hutu erupted, but I would not say that it was a deciding factor in concluding that genocide happened in Rwanda. In Sudan, again, especially by the defenders of Omar al-Bashir, the colonial issue was brought to the court, but again, it was not the core issue that was discussed by the ICC when the ICC issued the second arrest warrant against Omar al-Bashir. But in Ukraine, I would say that this colonial, post-colonial optics would be crucial for understanding that the crimes that we are observing in Ukraine are not just incidental war crimes or even not crimes against humanity, but quite often they reach this threshold of the crime of genocide. So that's another challenge that's quite complicated, but if we join efforts, and by we, I mean international lawyers, historians, linguists and others, if we join efforts to basically work towards comprehensive theory explaining how genocide unfolded in Ukraine, I think it's quite doable to construct qualitative cases on genocide in Ukraine. Sorry for being too long, but yeah, that was my last piece.
Thank you. It's not too long. Thank you. Thank you very much for this thought-provoking presentation, and thank you for stressing the issue of amnesty versus peace agreement. This problem of trading justice for peace actually is really very important, and we know that whenever international crimes are committed, such as genocide, torture, and other, it's always the issue: is it possible to trade justice for peace? Genocide is not the crime to be traded, certainly, because this is jus cogens, no, and this is important. I thought provoking because the challenges which you nominated at the end, those are challenges of procedural character. But I think there should be a concept. I mean that the crime of genocide is being committed. For this to be proved, we have to prove the intent, and this is already procedure: how to prove the intent, how to gather evidence. So I don't think that this is challenge for identifying the crime of genocide, but the challenges which you enumerated, these are challenges for proving the crime of genocide. But thank you once again very much. If there are some short questions to Dr. Koval, you're welcome. If not, as I said at the beginning, there will be time for questions and comments at the end of all presentations. I don't see here. I do see Irina Knapfel. Please, your question.
Yes, thank you very much. Thank you for every participant. And my question dedicated to this very difficult tema, genocide. I've been a student of political science, so not international law. But anyway, this tema is very interesting for me. So as we know, genocide is the most serious crime in international law, but at the same time, one of the most difficult to prove, which Dr. Miroslava had said. So given to the inherited challenges of proving genocide under international law, how would you assess Ukraine's chances of securing a legal recognition of genocide committed by Russia? I mean, in your subjective opinion, to what extent will the final determination depend not only on evidence, but also on international political consensus? I would be very interested to hear your personal perspective on this complex issue. Thank you.
Thank you very much.
Shall I take it?
Yes.
I think it's very important to, again, delineate a political dimension of recognition of genocide and purely legal dimension. And those things should go separately, actually. On the political level, we have some recognition already, because some states adopted declarations by their parliaments stressing that the atrocities in Ukraine have some rather that there are some evidence that suggests that atrocities in Ukraine may be viewed through the lens of genocide. So those statements were already made. They were made not to say that genocide was committed in Ukraine, but rather to attract the attention of the international community to the crimes in Ukraine. And that was that can be seen also as the fulfillment of the obligation of states under the Genocide Convention that stresses that states should try to prevent crime of genocide, not only prosecute for the crime of genocide. So in terms of politics, there was some recognition already. And I don't think that we need some additional recognition that would say that legally speaking, we can say that crime of genocide was certainly committed, and that all the states, through their legal mechanisms, should try to bring to responsibility those who participate in the commission of that crime. More difficult question is whether we can legally prove it. And again, when it comes to legal case building, it very much depends on what jurisdiction we are talking about. If we are talking about, for instance, International Court of Justice, and we want to bring the issue of the state responsibility for the crime of genocide, it will be extremely complicated to win such a case in the ICJ. Even with the presence of all those evidence that we know about when it comes to both genocidal intent and underlying offenses, underlying acts that might be considered as genocide. If we speak, for instance, about Ukrainian courts, it's much easier to have the win there, to have the recognition by the Ukrainian court that the crime of genocide was committed by certain individuals. If we speak about International Criminal Court, I would not say that that the chances are high, that they are higher than 5%, if you allow me to go mathematics. With ICC, we probably won't see the prosecution of the genocide in the court. But it's not necessarily because the genocide case in Ukrainian context is weak. It's more because the ICC OTP, or the Office of the Prosecutor of the International Criminal Court, takes rather safe ways to deal with the atrocities. And those safe ways mean that they go into qualification that are easier to prove and that are not controversial and that would not require too much of legal theorization of the events happening in Ukraine. And then the last avenue would be foreign courts. I would say that's not settled yet whether we will see some successful prosecution in the foreign jurisdiction. This might happen, but the odds are that the foreign jurisdiction would rather try not to qualify events in Ukraine as genocide before there will be some international ruling, or at least qualitative domestic ruling in Ukraine itself. So that's a long answer to the question, but yeah, I hope that it at least gives you some perspective or some broader understanding of how this works.
Thank you very much.
Thank you.
Thank you. So now let me invite our next esteemed speaker, the Professor Dr. Stefan Weber. Dr. Stefan Weber is a professor at the Europa Institute, Saarland University, and attorney at law in Vienna, and a guest professor at the National University of Kyiv-Mohyla Academy. He acts as an arbitrator and advises governments and private entities with a focus on European law. He holds degrees of Dr. Juris from University of Vienna, LLM from Harvard Law School, and he also completed habilitation in Vienna School of Economics and clerked at the Austrian Constitutional Court and the European Court of Human Rights. He teaches European Union law, financial market regulation, and international dispute resolution, and his research interests include general theory of the state, regulation, media, and human rights. In his presentation today, Professor Weber will speak about protected groups under Article 6 of the Rome Statute of the International Criminal Court. And let me share presentation of Professor Weber. I think this is your presentation.
The green one.
The green one, sorry. Share. So I hope our audience online sees the presentation, right?
Yes, we do.
Yes, you do.
Correct.
Thank you. And we also see the presentations. Thank you. So Professor Weber, the floor is yours.
Yeah. Thanks, Miroslava. Thank you also, Dimitro, for sealing and actually qualifying the legal challenges. I will now do the other side basically and try to do a bit of legal case building and not coming from the political side, but coming from the core legal side, from the advocacy standpoint. Because at the end, what will happen, eventually a court will decide. And the crime of genocide is a crime which is regulated in national laws, but it is also regulated international. And today we have here the Article 6 of the Rome Statute, and we also have Article 2 of the Genocide Convention. Maybe the next slide.
Oh, I wish I know how to do it.
Maybe the other one.
Roman, scroll down or
Yes. І приберіть zoom ці
what?
трошки
Uh-huh. But it doesn't work. I am scrolling, but I mean, the arrow, it doesn't work. Would you please help me? Mouse?
Yes.
Aha, with mouse, I see. So doesn't want to.
Mhm.
Well, how did you, which arrow? Up, down?
Право,
Ah, right, okay.
But
So the next one,
next one, yeah.
Yeah.
But it doesn't show the whole slide. So yeah,
doesn't show the whole slide. How to show the whole slide?
but this is also not the whole slide. So
I mean, it should be up.
yeah, that's it. Great. Yeah, I think what we have always to think about is that what we are talking today is Article 6 of the Rome Statute and Article 2 of the Genocide Convention, and eventually a court will decide. So for me, the main goal of today is to lay the groundwork for developing a strategy for future court proceedings. And I have to admit, I think as far as Dimitri too, we don't have a strategy on that, because it's a quite complex situation here. But what we have is that we have in court proceedings, we will have a well-prepared opposing parties. And starting from there, if we want to win a case in court, we have to vigorously scrutinize the situation as such, our position and the position of our opponents. And if I take military speak now, the enemy forces and the friendly forces, we could also in court, there will be representations from two sides. And I have two problems actually in the discussions, typically around genocide, because it suffers from inflammatory use in political and media communication. And you have that with Gaza, you have that also with Ukraine. And if you add up all that regarding the two main issues, which is the intent that was already mentioned, and the second one is the protected group. Do we fall under a protected group as such? I want to caution against taking these issues as easy rights. At the end, we are running into headwinds when we discuss that. Next slide, please. Yeah. So if we take a look into Article 6 of the Rome Statute, or Article 2 of the Genocide Convention, I basically assume that this is common knowledge already, what is written here. We have, if we start from the protected groups, we have four groups. We have the national group, we have the ethnic group, we have the religious group, and the racial groups. Only these are protected. And if we analyze the legal approaches for that to find our positions, there are two positions taken. The leading one, which is articulated by William Schabas. Schabas is the main legal writer on genocide. He sees these four groups as interdependent. So the concepts overlap. They help to define each other. They operate basically as four corner posts. And within these four corner posts, a myriad of groups find protection. My approach on that is they are also independent concepts. So if they're independent concepts, we have to find ourselves, meaning Ukraine, either as a national group, or as an ethnic group, or as a religious group, or as a racial group. Either we are in or we are out. This is from a legal point of view and from an advocacy point of view clear, and this is what we have to think. So don't be trapped in an echo chamber on that. This is what we have to prove. If we talk through, I'm actually not really an expert on ethnicities in general, and from the ethnicities in Ukraine, I have an overview, as everybody from outside has an overview. You have arguments that there is an intent to destroy the Ukrainian ethnic group. And if you have it as interdependent concepts, it's easy to argue. You can also argue the religious argument, even though the Ukrainian Orthodox Church, with its two branches, with the Moscow Patriarchate and the Ukrainian one, it is difficult to argue, but you can argue. The issue starts with national group, because this is the one which, from the outside, would fully apply to Ukraine. Because if you take Ukrainians and all, it's not a racial group, of course, it's not a religious group, it's not an ethnic group, because what you are and what you are proud about, and that's what most people like about you, that you are multi-ethnic, but you have to be a national group. And here we are in the first bottleneck, how to define national group and what is a national group, what makes up a national group. Next slide, please. So Mr. Schabas was always citing Lemkin, and I'll come to that later. I did a research on the basis of the general theory of state, and also looked into Lemkin's environment, who was the drafter of the Genocide Convention, and I came up with what in the 1920s, 30s was the legal thought in the German area. And my point is that these thoughts of the drafters of the convention were basically influenced by people like Max Weber. He's, by the way, not a relative himself, and of Hermann Heller, one of the leading scholars in general theory of the state. And my theory goes from there. Next slide, please. So when we then have to define national group in order to fully get into the scope of genocide, we have to first make clear that the legal term of national group does not correspond to any benchmark nations. It has also nothing to do with romanticist ideas articulated by colonialist or continental imperialist movements like the pan-Germanic or pan-Slavic movements. It's also not related to modernist ideas seeing nations along a continuum from a tribe to nations, also not with critical ideas that see the nation state much into discussion on the critical theory at the time, that see it as an imposed structure mismatching local identities and traditions. Also not nationalistic ideas that see history as one way towards the fulfillment of a national project, and all other positions that see nations through the eyes of nationalism or critical analysis in an ideological way.
Та то я просто слухаю одну конференцію про геноцид.
Будь ласка, виключіть мікрофон, хто це зараз говорить.
Це добре, значить, слухають.
So
Yes, go on.
next slide, please. So when we start from this politically cleaned concept of national group, we basically see two approaches. We see one leading approach by Mr. Shabazz, and he's citing Lemkin. And he says basically with national group, we mean a national minority. So he says Lemkin wanted to protect national minorities from oppression on the account of nationhood, race, or religion. So national minority encompasses all these kind of groups. So national group in this context refers to the national minority. The other approach, which I'm advocating, is national group refers to a defined national group as an independent concept. If we take these two approaches together and compare them, we always have to ask the question, which nation is to be defined? If we take the national minority approach, the affected group is the minority within a nation. So the question for us is, if we take the minority approach, is Ukraine a minority within a nation? This would be the Shabazz, the traditional approach to that. If we take the self-referred national group approach, which is my approach, the affected group itself is a national group. The question boils down to this boils down to the question, what is the reference nation? The reference nation.
Чи добра організація праці, чи ще якісь і групувалися, називали це чинники, групувалися такі речі.
І оголосіть всім.
Будь ласка, всі відключіть мікрофон. Прошу всіх відключити всі, говорить лише доповідач. Sorry.
So the question is, what is the reference nation? And if we take the traditional Shabazz approach, which is the leading opinion in the field of genocide, please next slide. Now we have to.
I have to, I think, like this, no? Once again. Yeah, thank you.
So we find ourselves in the second bottleneck. So if we take the national minority approach, I'm citing here, you may know that this is an article that was published in July 2021. It's a view proposed, the greater nation, the greater Russian nation, which united the Veliko-Russians, the Malo-Russians, and the Belarusians. If you go to the national minority approach, then the national minority group would be the Malo-Russians. You find yourself in a paradox situation where you may actually have to advocate such a position in order to get into the genocide argumentation. The second way, if you argue, is that there's neither a minority nor a self-referred nation approach. You can say Ukraine is just a state. Ukrainians are citizens of that state, and there's neither a national minority nor we have a national group. So then you are trapped between two chairs. Or the last one, which is my approach, that the self-referred national group is Ukraine, but then you have to define what means national group within the meaning of the Genocide Convention. And this is the points which I have basically developed on the basis of Max Weber and Hermann Heller, which is a group of individuals characterized by relationships. There's a sustainable political sense of and will to cohesion. There are values and norms shared, and there's the same geographical or societal territory and the capacity for self-governance. My point I want to make here is that from an advocacy standpoint, you might be trapped in a situation where two arguments actually go in the direct in totally indirect dimensions. And of course, all the arguments which you put from the other side will be put forward by the counterparty. And then, as you said before, at the ICC only want to do safe cases. So it's not a question of the safe case, it's not a question of evidence, but it's a question of legal argument. And I think this is what we have to take care of and really put forward. Next slide, please. If you now go to national group in the self-referred national group definition, which I'm advocating here, what makes it now up to be a national group? And for Max Weber, whom I'm citing here, the most important things is common political achievements and collective political memories. And these political memories that are capable of transcending ethnic, religious, and other differences. And what is basically a nation is a politische Erinnerungsgemeinschaft, meaning a community based on common political experiences and memories. And this is an argumentation which goes against Lemkin and against Shabazz, but it's also based in the historic environment of the drafters of the Genocide Convention. The other elements are sustainability and forward-looking attitude. The main point is that the national group has to have the ability to continue over a long time, and it's with a view into the future. It's for the present, it's for the future, and of the past. So, and I will have the counter arguments in a minute, but the other things are I think for Ukraine are not important. It's geographical territory. You do have capacity for self-governance. It's relevant in another given context, but not in that. Next slide, please. So then we have this, as the defining point is the political will to cohesions. It's all other factors like history, language, way of life, religion, ethnicity, culture are not the defining elements. They are just indicators for this political will. The examples which I've written down here actually are the ones which are proposed also in this article, which was published in July 2001 as the arguments in favor of this unity. And what did they cite? They cited a common history, a historical and spiritual place shared, a common faith, a same ethnicity, similar equal language, and the same economic system and ties. The basic point is that a common history, it always depends on how to interpret it. So the same history may give rise to competing views of the history, and then it goes the other way around. And so all these arguments which were put forward here, I'm writing against it. And common faith in the same thing. If you have one faith, this is not nation. If you have a common faith, it's religion. And if religion is the defining element for a political will, you always have also to include, and it has to extend beyond this subgroup to include other members of other religions, and the same would be true for ethnicities. Similar language is never an issue, then Austria, Switzerland, and Germany would not exist, or US, United Kingdom, and Canada. And economic systems and ties, of course, also not. Next slide. So the one of the characteristic features also of a national group is that nations rise and nations fall. So the most important thing is that the awareness of the uniqueness and the difference in relation to other groups. There must be a political will to be a we, and a common feeling and awareness of the we. This is a citation of Hermann Heller. And one thing which is also important, and I think this is very true for Ukraine, that national group means political pluralism. In a national group, there's always a multitude of different groups, dissenting opinions, and the pluralism of political and cultural positions. So, and I want to close here with one line of Hermann Heller. There is no active political unanimity of a national will at any time and anywhere. My point is, be clear that if you want to make a legal case and you want to do case building, please also engage in hardcore legal analysis. And this is where I wanted to lay the ground here a bit, and I'm happy to discuss and hear other views in that context. And yeah, that's it.
That's it. Thank you. I will stop sharing. And I would like to see, I don't see any hands in the online.
I hear one.
There is a question from one of the speakers, Dr. Koval, please. You have...
Maybe not a question, but a comment that would help to bridge what I was talking about with the latest presentation. So I frankly very much liked that you used several times the word politics or political group or political interest of the group. I would say that most of the commentators of the crime of genocide, especially the crime of genocide in Ukrainian context, they shy away from using this term because for them, saying that the selection of the victims was somehow based on the political interests or shared political values means that this was not a genocide but some other type of crime that targeted the political groups rather than a national group. So I think that's rather goes against the common sense, but also the indeed definition of national group. Even if we take into account the only definition of national group that is there in the International Criminal Court's practice, the one that was given in Nakayesu case by the ICTR, the way they defined national groups has to do with politics because it's about citizenship. And citizenship is the continuation of the state policy towards people living in the territory of that state. So I very much like how you actually characterize national groups through the lens of political interest and other things. But now come the bridge that I promised in the very beginning. I mentioned that one of the challenges would be to prove genocide using these optics of post-colonialism, and I still think that it's quite a case. Maybe not in the objective side of proving that the national group was targeted, but on the subjective or mens rea side, because we should not only prove that national group of Ukrainians exist, but also we have to prove that Russians kind of understood the victims of the atrocities as a national group of Ukrainians. And that's where the challenge starts, because because obviously Russians didn't target all those who were representatives of Ukrainian national group. They selectively cherry-picked some of the victims, right? Even in the locations where there were thousands of victims, like for instance in Bucha or Mariupol. And this cherry-picking has to do with the wrong view of Russians on the Ukrainians. They basically considered Ukrainians as part of a bigger Russian nation, and they thought that only some representatives of Ukrainians, somehow they called nationalists, share this idea that Ukrainians are a separate nation. And they, at least at first, targeted those who kind of opposed Russian view of Ukrainians as somehow Russians, right? And I think that that's where this post-colonial lens helps a lot, because it explains how through the history, centuries of Russian dominance on Ukrainian territory, this attitude towards Ukrainian nations developed, and how it framed and shaped Russian approaches to who are Ukrainians and who are not. And that's where, again, politics plays a role, but also this history, this context also is very important.
But the paradox thing about this is that with this Russian imperialistic approach, you can also trap Russia to commit genocide, because then if you take the Shabazz approach on the national minority, they are a national minority. So that's this is the paradox situation, and this is also difficult how to frame an argument as a prosecutor or in helping a prosecutor.
Thank you very much, Professor Weber and Professor Kowal, for comments. So thank you for stressing this issue of protected groups, of the Ukrainian national group in the context of protected groups under Genocide Convention. That has been an issue for Ukrainians for centuries. We were denied the ethnicity, the nationality. We were Ukrainian ethnic group while we didn't have statehood, and we didn't have statehood for centuries. But after we gained independence and we created a state, we are definitely a national group. So from this point of view, I don't think that international court, if criminal court, if it will hear the case of genocide, it will stand on the position of Putin that Ukrainian nation doesn't exist or something like this.
Well, there's no case law on that. So it could be that the argument could be it's just a state.
Mm-hmm.
And if you take the Shabazz approach, you are not a national group. This is the point. So you have to really make an argument and build this argument, and I think this is also a goal for the next steps to come. That you have to build this argument.
Thank you very much. And now we go on with our presentations, and our next speaker is Dr. Yulia Anosova. Let me say a few words about Yulia Anosova. Dr. Yulia Anosova is a researcher and practitioner specializing in international law and human rights. She obtained her PhD degree in international law at the National University of Kyiv-Mohyla Academy in 2019. During the past 5 years, she has been actively involved as a lawyer and legal expert at Ukrainian civil society organizations, working with the issues of gender-based violence, human trafficking, children and women's rights. Since June 2023, she is a postdoctoral fellow under the MACA for Ukraine Fellowship at the Human Rights Center of the Faculty of Law and Criminology of Ghent University. And Yulia's paper today is National Courts or the ICC, National and International Dimensions of Liability for Sexual Violence Crimes Committed in the Course of the Russian Aggression Against Ukraine. The floor is yours.
Thank you, Professor Antonovich, for introducing me. My presentation is not on the crime of genocide, but on another crime which is pretty much on agenda in Ukraine. But I will touch upon some aspects of the crime of genocide that's overlapped with the issue of genocide. My presentation is on conflict-related sexual violence in Ukraine, and I should mention that the incidents of such violence were registered in Ukraine since the beginning stages of war in 2014, but only with full-scale invasion, the incidents intensified and were registered, being registered on much wider scale. There are hundreds of conflict-related sexual violence cases documented and reported by international organizations, in particular Independent International Commission of Inquiry on Ukraine, by the Office of the United Nations High Commissioner for Human Rights, by other international organizations and Ukrainian NGOs. In its recent judgment on in the case of Ukraine and Netherlands versus Russia, the European Court of Human Rights confirmed that conflict-related sexual violence is strategically used as weapons of war in Ukraine, and the court qualified it as a serious violation of Article 3 of the Convention, in particular as torture and inhuman and degrading treatment. As of July 2025, the General Prosecutor's Office of Ukraine officially registered 368 incidents of conflict-related sexual violence in Ukraine, which were committed against 232 women, 136 men, and 19 children. As of today, 85 perpetrators were accused, specifically with conflict-related sexual violence as a war crime, and 18 persons were convicted. Most of the trials took place in absentia. Those numbers are quite significant, but still are not representative of the real situation because due to huge underreporting as well as lack of access to the occupied territories, the numbers are much higher, and international organizations claim that the numbers might be 10 to 20 times higher than officially registered numbers. So what is the situation with the current legislation about conflict-related sexual violence in Ukraine and how it is qualified according to national legislation and also according to international law. So according to international law and also Ukrainian legislation, which tries to follow international legal standards, conflict-related sexual violence can be qualified as war crimes, crimes against humanity, and genocide. As of today in Ukraine, conflict-related sexual violence is qualified mostly as war crimes under Article 438 of the Criminal Code of Ukraine. However, it should be mentioned that currently evidence and incidents of CRSV are also used, and General Prosecutor's Office is trying to include them as in cases in current proceedings on genocide as well. There is no explicit strategy of regarding instances of conflict-related sexual violence as genocide, but there are indications that it will be a strategy of the General Prosecutor's Office in the near future. So in 2024, Ukraine ratified the Rome Statute, and the same after a few months, it also adopted changes to the or amendments to the Criminal Code of Ukraine. And in particular, these changes concerned conflict-related sexual violence. So first of all, sexual violence, crimes related to sexual violence were included under the title of crimes against humanity into the Criminal Code of Ukraine. And in fact, this provision currently it pretty much is in accordance with the respective provision of the Rome Statute. So the list of sexual violence crimes in Ukraine under the heading of crimes against humanity is in compliance with the Rome Statute provision. However, when it comes to other crimes, such as war crimes, the situation is not as clear. But first of all, I'll mention the crime of genocide. And again, the strategy to prosecute conflict-related sexual violence as a crime of genocide. So among these recent amendments, Ukraine also, let's say, concretized the definition of genocide, mentioning that inflicting of serious harm might include also committing rape or other kinds of sexual violence. So rape or other sexual violence were explicitly mentioned as possible serious harm in the context of the crime of genocide. So as of now, I see it as a part of a strategy for future prosecutions of sexual violence, also as a crime of genocide. As for another aspect of these amendments, in particular, improving the definition of the war crimes. Unfortunately, as of now, sexual violence is not explicitly included into the provision of war crimes. However, actually the situation did not change compared to what was before these amendments. And in order to qualify sexual violence as a war crimes, currently judges or law enforcement, they have to refer to specific provisions of international treaties ratified by Ukraine, in particular Geneva Convention, which mentions sexual violence as violations of international humanitarian law. So this is some aspect which still needs improvement in terms of qualification of sexual violence as a war crime. Also, I should mention some other legal developments, in particular concerning definition of conflict-related sexual violence. Such definition was included in legislation, in particular in the newly adopted law on legal and social protection of victims of sexual violence related to armed aggression of the Russian Federation. So we now have official definition of conflict-related sexual violence. However, in terms of criminal prosecution, this definition cannot be directly applied since this law is not part of the criminal legislation of Ukraine. Another issue is including some standards, some international legal standards on prosecuting conflict-related sexual violence in the criminal proceedings, in particular in the Criminal Procedure Code of Ukraine. Actually, there are different initiatives, including draft laws, which are aimed at adding some special provisions on prosecuting conflict-related sexual violence in Ukraine and special proceedings related to this prosecution. However, these draft laws, specific draft laws, were not yet adopted. Nevertheless, there are many developments in terms of institutional changes and some procedural policies and practices related to prosecution of conflict-related sexual violence in Ukraine. And actually, they are pretty much, I would say, indicative of what is of the developments of prosecution of international crimes in general. So in terms of adoption of new policies, there are at least 3 different policies of the General Prosecutor's Office of Ukraine addressing specifically CRSV. First is strategy on victims and witness-oriented approaches in cases of conflict-related sexual violence adopted by the General Prosecutor's Office in 2022. Also, there were adopted 2 strategic plans, specifically one strategic plan on prosecuting conflict-related sexual violence and another a strategic plan on prosecuting all international crimes for the period of 2023-2025. All of these strategic plans, they mentioned specifically prosecution of conflict-related sexual violence and put it as one of the main focuses of activities of the General Prosecutor's Office of Ukraine. Also, the General Prosecutor's Office of Ukraine adopted different guidelines on how to investigate and prosecute different forms of sexual violence. And it is important because these guidelines include prosecution of such forms of sexual violence which are not currently, let's say, standardized under international law, but which are committed in Ukraine. So they provide further information and guidance to the law enforcement authorities of Ukraine on how to deal with these cases. Examples include such crimes as forced nudity, for example, or threats of sexual violence, and so on. Notwithstanding all these practices and policies, unfortunately, they are not yet part of the solid legislation, so they were not included into the Criminal Procedure Code of Ukraine and currently are just some practices implemented by the General Prosecutor's Office. Also, I should mention some institutional changes, institutional changes in the Office of General Prosecutor's Office of Ukraine, which also facilitate investigation and prosecution specifically of conflict-related sexual violence crimes. In particular, the establishment of the unit, of the special unit specializing on the investigation and prosecution of specifically conflict-related sexual violence in Ukraine. And this unit is included into the more general, let's say, department in the office dealing with all international crimes. Another institutional change is also introduction of the coordination center for witnesses and victims of crimes. And the focus, one of the main focus of this coordination center within the General Prosecutor's Office of Ukraine is actually dealing with victims specifically of conflict-related and sexual violence. So it was short introduction of what is happening at the ground level in Ukraine in terms of prosecution of sexual violence. But what is now the question is how the national system and international system are interact, and whether this interaction or cooperation is possible, and which functions are currently which are the functions of the national and international system. At the national level, as I mentioned, majority of the cases, currently the majority of conflict-related sexual violence cases are dealt with at the national level by national courts and national law enforcement, but there are many challenges, specifically in judicial system. For example, the courts are understaffed. Just to give an example, there is currently a deficit of 50% of the appeal court judges are not appointed, so there is a deficit of personnel. Also, the number of cases, the sheer number of international crimes which are currently investigated and prosecuted, which is around 150,000 cases, and all these cases are dealt with by the national criminal justice system, and obviously it's too much overload. Let's say of courts are overloaded by this number. Also, there is an issue of destruction of infrastructure and dire conditions under which Ukrainian courts have to work. Absence of specialization and I would say lack of specialized training to the judges and law enforcement professionals. And of course, the conduction of almost 85% of all trials in absentia. So these are the challenges which national criminal justice system currently has to face. Nevertheless, in course of my research, I conducted interviews with judges, with prosecutors on the ground, and they don't see it as a big problem. So they are currently involved into their work, into their normal work, and do not consider this prosecution of international crimes as so they consider it as their own responsibility and not something to be given to some international, let's say, courts or some other international or other mechanisms. At the same time, there are not only national mechanisms but also international mechanisms which can be and should be involved into prosecution of international crimes. And first of such mechanism is, of course, the International Criminal Court, which has jurisdiction of over sexual violence crimes, either as war crimes or crimes against humanity or genocide. Currently there is quite clear vision at the political level on the modes of cooperation and distribution of the cases with the International Criminal Court. And this vision is actually expressed in the policies. On the side of ICC, it's quite clearly expressed in the policy on complementarity and cooperation adopted by the ICC in 2024. Which directly states that ICC sees its role in investigation and prosecution of the crimes committed in Ukraine as such that it will identify patterns and focus on common responsibility while dealing with high-profile cases. And Ukrainian national criminal justice system, it will deal actually with main so the main effort on concerning prosecution of international crimes will be on shoulders of Ukrainian criminal justice system. But in this, ICC is ready to provide its support and develop capacities of the national criminal justice system to ensure that it will really be able to deal with international crimes. So in terms of the language used by the International Criminal Court in defining this mode of cooperation, there are like two types of such like interaction with the national criminal justice system. So it's both negative and positive complementarity, with negative complementarity being readiness of the ICC to take some high-profile negative complementarity. Readiness of ICC to take high-profile cases, which might be too difficult for Ukraine to deal with, at least as of now, and positive complementarity being strengthening of the national criminal justice system and its ability to prosecute international crimes. In terms of other international mechanisms, of course, it should be mentioned universal jurisdiction. And one of the recent examples is a case submitted to the German courts by the Clooney Foundation for Justice. And this case concerns specifically CRSV. And it is also noteworthy that this case concerns common responsibility and not direct perpetrator, which means that potentially, this universal jurisdiction mechanism can be used for high-profile cases as well. Another mechanism is a joint investigation team, which into alleged crimes committed in Ukraine, which works under auspices of Eurojust, and which currently has jurisdiction over war crimes, crimes against humanity, and genocide. Even though, as of today, I would say the activity of this mechanism is not very transparent, so we don't know which are the cases as this mechanism is dealing with, but potentially it has jurisdiction to deal with conflict-related sexual violence cases as well. So to conclude, I should mention that there are many challenges which national criminal justice system of Ukraine has to deal with on the path to prosecution for conflict-related sexual violence. But at the same time, there is also involvement and readiness of international mechanisms to assist in prosecuting international crimes, which Ukraine actively supports. And even though as of now we do not see quite explicitly the results of this involvement of international mechanisms, but we see that they are these mechanisms are already being involved and they are working. And in the future, we will see, we hopefully will see some result of this cooperation of national and international mechanisms.
Thank you very much. And welcome Alonsova for clearing out for us this dilemma, national courts or ICC, or both, should be both. So, and thank you for stressing that this gender, sexual violence in armed conflict can be qualified as war crimes or as crimes against humanity, or even can be relevant for determining specific intent of genocide. It can be relevant as well. So any questions from the audience, short questions? There will be time for questions after all the speakers. I don't see any questions, so we go on. And our next speaker is Dr. Natalia Subotina. A few words about Natalia Subotina. So Natalia obtained a PhD from the Ukrainian Free University, majoring in international law and minoring in philosophy in 2025. From 2021 to 2024, she was a holder of the Konrad Adenauer Foundation Scholarship for doctoral students in Germany. She was also a coach for international law moot court competition and a lecturer at the Ukrainian Catholic University. Earlier, she received an LLM in human rights law from Ukrainian Catholic University, spending a semester at Tilburg University, the Netherlands, under the FUCE scholarship. Her current research interests include human rights, the environment, and culture, both during peaceful time and in situation of armed conflict. Dr. Subotina's presentation today will be on does the destruction of cultural heritage in Ukraine fall within the scope of the Rome Statute? And I will share presentation. This one?
Yeah, this one.
Good. Share.
And спочатку from the beginning.
This is not from the beginning?
No, on the top of it,
Спочатку.
like the full screen mode.
I click on this.
Yeah. Okay.
Okay. I will check if it moves.
Yeah.
Just a moment. And I think yes. Yeah.
Yeah, good.
How to go back? This is a question. Okay.
Yeah, great. So good afternoon, everyone. I'm really happy to be here and to share the beginning of my research in this new field because my PhD dissertation was dedicated to biodiversity, and our culture is a pretty different issue. But I think this picture by Maria Primachenko kind of vividly illustrates the relevance of both, and it is a smooth transition of me personally from nature to culture. But this image is placed here not only because of my personal transition in phase, but because this is highly relevant for the topic we're discussing today. And as Yulia mentioned, in case of the crimes that she covered, the crimes were relevant, the crimes at issue were committed in Ukraine since 2014, but the level and the scope of those crimes intensified with the full-scale invasion. And this is one of the pictures that was saved from the Ivankiv Historical and Local History Museum, which was targeted on the 25th February 2022. So the second day of the full-scale invasion already was a date when culture of Ukraine was vividly targeted by Russia. And answering the question of today's presentation, does the destruction of cultural heritage in Ukraine fall within the scope of the Rome Statute? Well, the short answer, yes, it does, but partly. And in the course of next 15 minutes, I will elaborate on how exactly. Next slide, please. On this slide, we can see the recent example of how the cultural heritage of Ukraine was targeted by Russia. In June, or exactly on the 10th June 2025, the St. Sophia Cathedral, which is part of the UNESCO heritage site in Kiev, was targeted. Luckily, it was not destroyed, but some of these eastern site components were damaged. And in 2022, in May 2022, we've seen the destruction of Kirkoris Delitory Memorial Museum, which suffered to a greater extent. And overall, we know numerous examples of destruction of cultural property. Next, please. It's not the slide, but it's the information, the statistics from the Ministry of Culture and Strategic Communications, which
This one?
No, yeah, this one, which calculates the damage. And the recent statistics as of May 2025, almost 1,500 cultural heritage sites were targeted and partially or fully destroyed, and over 2,000 cultural infrastructure facilities, including cultural clubs, libraries, museums, galleries, theaters, were also targeted, with 436 completely destroyed. And this data only covers those which are no longer on the occupied territories, because the data from the occupied territories is naturally missing. We know only of some instances of how the museums on the occupied territories were relocated to Russia, or how the archives were relocated, how the archaeological sites were also destroyed or damaged. Next, please. Now, as we are in Germany, we will move a bit to the German context, or to a wider European context, and not narrowly focusing on the current events. I'll try to guide you through the history of cultural heritage and international law, but quite briefly. On this picture, you can see one of the pages from the book of the 13th century, which was stored in Bibliotheca Palatina of Heidelberg. And during the 30th-year war in Europe, this library was conquered by Maximilian of Bavaria.
Thank you for interrupting, but we do not see the change of slides. So
Oh,
not
such a-
able.
Thank you for letting us know how to, they do not see how slides are changed. Yes, so, sorry, we will correct it now.
Окей. Або, знаєте, що спочатку відкрити. Спочатку відкрити. Спочатку.
Може, не приходить в такому, який
Але тобі треба поширити.
А якщо з цим лівим стовпчиком, може так рівні?
Може так буде.
Так воно буде. Лівим стовпчиком і буде не повністю
Зараз я
видно.
спробую вставити вас.
Ага.
Тут так.
І тепер почнете через Zoom.
Нема. А це не ця.
Може через ці так стрік.
Do you see now? Do the slides change now?
Yeah.
They
Okay,
do, good.
great.
Yes,
Thank
very
you,
much.
thank you a lot. Yeah.
So
So-
I will briefly show the previous, so that as far as you didn't see, so that you see now. That was the previous slide, and now we have this slide.
Yeah, so we can stop here. Or you can even click the next one.
The next one, good.
Yeah, good. So now we are on the same page, great. And so continuing with this story, this library was seized by Maximilian of Bavaria from the House of Wittelsbach. We are now at the university which is near the Palace of Nymphenburg, and this palace was built by successors of that Maximilian. So it's like pretty relevant to our location. But the story is that he decided to give this library as a gift to Pope in Rome. And until today, most of the works are located in that Bibliotheca Apostolica Vaticanum. This library was one of the most important or meaningful collections of German Renaissance manuscripts and also printed books. So it was pretty important for this area. And then with the Peace of Westphalia, which ended the 30 Years' War, the situation didn't change much because these peace treaties, they dictated that plundered property would not be restored, but it allowed for limited return of writings, documents, and other movables. Some change occurred after Napoleonic Wars. As we know, Napoleonic Wars, they pretty similar to what is the modern meaning of the looting of cultural objects and the use of ancient historic and artistic objects and symbols of modern national identity and political legitimacy received new incarnation during the Napoleonic dream of recreating Paris as New Rome. And for this purpose, he was collecting artifacts from different parts of Europe and also Egypt. But this ambition of Napoleon was also met with the British ambition to make London as a second Athens. And then, after Napoleon's defeat, the victorious allies, which assembled in Wien to this Congress of Vienna, they demanded restitution of cultural objects. And only half of the works returned after all. But what is interesting in light of this Bibliotheca Palatina, in the end of 18th century, a Pope has given some of the books from that collection to the French Republic. And after the Congress of Vienna, those books which were given to French Republic, they were returned to Heidelberg rather than to Vatican. So basically, almost 200 years passed since the time those were captured during the 30 Years' War, and then they were returned to Heidelberg. But the major shift occurred 50 years later, roughly, when the Liber Code, the so-called Liber Code, which is the instructions for the government of armies of the United States in the field General Order number 100 of 1863, was created during the US Civil War. And that US Labor Code inspired also the conclusion of the Hague Conventions of 1899 and 1907 in Europe. Next, please. And the Labor Code and quite similar wording in the Hague Conventions provided that in sieges and bombardments, all necessary steps must be taken to spare as far as possible buildings dedicated to religion, art, science, or charitable purposes, and historic monuments, provided they are not being used at the time for military purposes. Next, please. And it also provided that these institutions are to be treated like private property, even if they were state-owned. So here we see the importance of these buildings of special kind dedicated to religion, art, science, and then later you will see how it is relevant to the Rome Statute. But next, please. But before that, we know that during the Second World War, the issue of culture was also at stake. And Nuremberg International Military Trial convicted Alfred Rosenberg. There were no separate crimes against culture or something like this, but he was tried for crimes, for war crimes and for crimes against humanity related to taking cultural property also at large scale. Next. And so more recent sources established after the Second World War. Why these sources are relevant in general, if we're focusing today's event on Rome Statute, but we know that according to Article 21, the ICC can also take a look at other sources of international law, not only what is written in the Rome Statute or elements of crimes themselves. So the key instrument concluded in 1954 and relevant until today is the Convention for the Protection of Cultural Property in the event of armed conflict. It also has two protocols, the first of 1954 on movable property and second protocol of 1999 trying to enhance the protection of certain specifically important cultural property sites. The International Tribunal for Former Yugoslavia also was relying on this convention as a reflection of customary rule of international law. And the additional protocol to the Geneva Conventions also is based basically on the provisions of these conventions. So the Article 53 of this first additional protocol to the Geneva Convention is operating without prejudice to the Convention of 1954. We also see some other conventions here, of which I'd like to draw attention to the Convention for the Safeguarding of the Intangible Cultural Heritage. And in general, you can see that in red colors, certain terms are highlighted on this slide. This is done for purpose, because when we are talking about protection of cultural heritage, it is crucial to understand what is in general meant by this term. Even though it has been affected for centuries during the wars, by the armed conflicts, there is kind of still no comprehensive provision governing all cultural heritage protection during the war. As we see, the Hague Convention is of 1954 is focused on cultural property. As we see, the Hague Conventions of earlier times of 1907, for instance, they were focusing on buildings containing certain cultural proprieties. And then we see the Convention for Safeguarding the Intangible Cultural Heritage, which is quite new. It's like 2003. And intangible cultural heritage means also various processes, the acts of performing something, also traditional craftsmanship. So basically, lots of other dimensions of culture which we cannot document that easily and which cannot be restored that easily once it is ruined. And also the Hague Convention of 1954 and the additional protocol, it seems like they're not governing all of the cultural property in tangible sense, but also the most important ones, constituting, for instance, cultural or spiritual heritage of the peoples, meaning it has to be of importance to the whole nation, if we can use this term. Yeah. Next slide. Some of the recent examples of major destructions of cultural heritage. We see the 2001, sorry, there is a mistake, it has to be 2001, not 2021, the destruction of Buddhas of Bamiyan by Taliban in Afghanistan, which generated international reaction to it. UNESCO issued a separate declaration on intentional destruction of cultural heritage in context of this destruction. And then on the second picture, we see reconstruction of the destroyed mausoleums of the Timbuktu in Mali. And this case of various destruction of cultural property in Mali is immediately relevant for the Rome Statute, because the first case heard by the ICC in the realm of cultural property and dedicated solely to the cultural property was related to the events in Mali. Next slide, please. And so when we talk about Rome Statute, as was the case with the crimes in realm of sexual violence, it could be qualified under different elements of crime, and different components of the crimes basically covering all of these. But today we will focus on 3 of them without the crime of aggression. Next, please. And what is important, even though we don't see like culture mentioned exactly specifically among these 4, the crucial document here is the Policy on Cultural Heritage by the Office of the Prosecutor, issued in 2021, explaining how culture is relevant to all of these crimes, and the Office of the Prosecutor uses the notion of crimes against or affecting cultural heritage. Next, please. And the office interprets it as broadly as they could. So basically, they are, for purpose, are focusing on cultural heritage as such, and not more narrowly cultural property or any other manifestations. It is not the case in the actual reading of the Rome Statute, but it is a very beneficial approach, I believe, to the cultural heritage here. So they write that it extends beyond cultural property to incorporate both products and processes. This term denotes a community's sense of identity and belonging, and involves cultural resources in both their tangible and intangible forms. Next, please. And so the most immediately relevant provision of the Rome Statute when it comes to the international armed conflicts is Article 8.2b9, which is intentionally directing attacks against buildings dedicated to religion, education, art, science, or charitable purposes, historic monuments, hospitals, and places where the sick and wounded are collected, provided they are not military objectives. What kind of provision is it reminding you of, out of what we've discussed today? Okay, I can help here. Basically, it is based on the Hague Convention of 1907, not the Hague Convention of 1954. And we see that it is not dedicated to cultural property, but it is about buildings dedicated to religion, education, art, science, or charitable purposes, historic monuments. Therefore, it seems like it does not include, well, it is like true from the writings that I read preparing for this presentation, that it does not include movable property, for instance, not saying about the intangible heritage. And what is important here is that, well, it has to be targeted intentionally, so with the intent to destroy those buildings, to attack them, and provided they are not military objectives. So basically, if these buildings are actively used for military purposes, they could be legitimately targeted. What is also important here is that the meaning of attack here is rather special one, which was clarified in Al-Mahdi case, and it includes acts directed against protected objects and under control of a party to a conflict, and not merely the adverse party, which is good because it enhances the scope of application. And there is also no requirement for proof of actual damage once the attack has been directed. So only directing is enough. Next, please. In approaching this war crime, the ICC may rely on the practice of the ICTY, which has a successful case of conviction of Pavlo Strugar for the shelling of Dubrovnik, a UNESCO heritage site. And there is also a contradictory practice of no conviction for the wanton destruction of the old bridge at Mostar, because the appellate chamber of the ICTY concluded that it was a military objective, and that's why it is not a crime, even though it was a relatively important object. Next, please. And on this page, we see the old bridge of Mostar and shelling of Dubrovnik, and luckily, the old bridge in Mostar was also rebuilt successfully. Next, please. Okay, and apart from that specific provision on buildings relevant for culture, there are, of course, general provisions on civilian objects, which are also applicable to all other kinds of property not subject to that special protection. but with the important difference that these must be not under the control of the same party. So basically, this lex generalis on civilian objects is not applicable to the cases of occupation, for instance, when the territory and property is already under the control of the party. And next, please. But what could be applicable to the cases of occupation is the Article 82A4 on extensive destruction and appropriation of property not justified by military necessity and carried out unlawfully and wantonly, which covers all real or personal property on occupied territory, and such instances of removing artifacts from the museums follows under the scope of this article. And these two articles in this category, they are also for the cases planned by state and also executed in the state interest, not for obtaining private or personal gain. Next slide. And for the appropriations for personal gain, like executed by soldiers of Russian army, the Article 82B16 is applicable on pillaging a town or place. Next, please. So this was about war crimes, and now turning to crimes against humanity. Of course, three basic preliminary provisions are always important when something is to be qualified as a crime against humanity, which means that it has to be an attack on civilian population as such, rather than on objects. It has to be pursuant to or in furtherance of a state or organizational policy, and it has to meet the criteria of being widespread and systematic. And several crimes against humanity seems to be particularly relevant in the case of Russia's aggression against Ukraine, which is, for instance, the deportation or forcible transfer of population, because this also covers the cases where people have to flee a certain region because they can no longer practice culture there safely. Also the persecution, which means depriving persons of their fundamental rights. And as we know, the right to self-determination also covers the cultural self-determination of the peoples. Then the torture, because as was stated in Al-Mahdi case, the mental element of suffering caused by the destruction of cultural property is also to be taken into account, not only the physical torture. And extermination, because destruction of culture may also facilitate mass killing by lowering the group's morale. Next, please. And now moving to genocide, the crime with which we started this event. In case of genocide, what is important, even though there is no notion of cultural genocide officially as a part of the Genocide Convention or the Rome Statute, the crimes against cultural heritage or affecting cultural heritage may serve as evidence of establishing this intent to destroy a group. And this was also confirmed by the cases of the ICTY and by the ICJ. In particular, just to read the quote. Yeah, so the ICJ in the Bosnian genocide stated that where there is physical or biological destruction, there are often simultaneous attacks on the cultural and religious property and symbols of the targeted group as well. Attacks which may legitimately be considered as evidence of intent to physically destroy the group. And in that ruling, the ICJ basically endorsed the observation in Kristic case of the ICTY. That's why it is important for if the case of genocide ever will be heard by the ICC in context of Ukraine, the cultural heritage destruction could serve as a point which helps to actually establish this intent. But apart from this, certain elements of the genocide, also as mentioned in the case of crimes against humanity, the element of mental harm could be related to the Article 6b of the Rome Statute, causing serious bodily and mental harm to members of the group. Also Article 6c, inflicting conditions of life calculated to bring about the group's physical destructions. Because so these acts targeting cultural heritage can also be qualified under this component. And of course, last but not least importantly, the forcible transfer of children to the territory of Russia has profound impact on cultural rights and on the continuation of the group's cultural heritage. Next, please. So yeah, that's almost the end of the presentation, and some final considerations. In this presentation, I covered mostly the international law aspect, but as was mentioned by Julia, the complementarity is of course an important point here, and most of the crimes against culture and cultural heritage have to be prosecuted by Ukraine, according to Ukrainian criminal code, and also another element of admissibility for the crimes before the ICC is the gravity. So basically gravity of the violations with respect to cultural heritage has to be assessed. The second consideration or a challenge is the need for an inventory, because to know what is being destroyed, one has to know what is already present on the territory, and for this reason, not only those items of culture that have been already damaged or lost have to be treated with scrutiny and registered, but also those cultural objects that are not harmed yet and hopefully will not be, but have to be protected and have to be inventorized. And then the challenge of intangible heritage, which I mentioned closer to the beginning, because it seems to me that currently it is the least protected category of heritage under international criminal law and also under national law. And in order to protect it, it is like, well, once it is gone, it is much more difficult to reconstruct it. And that's why I think we as Ukrainians have to just continue practicing our culture as it is in order to preserve it, and can do it also abroad, and then may bring it back to the damaged regions in Ukraine. And then I'd like to end it with a quote by Claire Smith, that previous slide. Yeah, like there is a quote. Destroying heritage is much more than destroying an object. It attacks and the signifiers of a society's history, its shared memories, its cultural values, and the ways in which life is imbued with meaning. Thank you.
Thank you very much. Very cool. This insightful presentation, but my hope that we have 1 hour for discussion at the end is
Gone.
No, it's coming to you then. Yeah. So because we still have 2 brilliant presentations, but I see a question from Ina. I don't see your last name, but you have a question. Please, Ina.
Yeah, thank you very much. My last name is Ina Krak. And first of all, I want to thanks for everyone, because we open very significant questions for all of us belong for Ukraine, and I'm really I wait of this moment when I can make notes what significant questions our speakers made for us, and what they conclude, and what question we can make about all of it. And it was very interesting, and I make a little bit summary about our speakers, and it's really very significant because, for example,
Ina, excuse me. Now we have time only for short questions.
Yeah. And
your question, please.
yes, and I made one significant question for all of our speakers. What do you think the Genocide Convention still fit today? Is a reality, or it should be updated or reinterpreted to be better reflected with Ukraine questions? Because we open other 3 different significant questions, and I'm just ask you if it's still fit today for this reality, or we can change something to help Ukraine.
Thank you very much.
Yeah, thank you very much.
I think that we will answer your question at the very end of our roundtable. We have 2 more presentations, and at the end of all presentations, we will answer your question.
Yeah, super.
Now I'm very happy to give the floor to Volodymyr Hryshko, Volodymyr Hryshko is a senior legal counsel at Truth Hounds and a PhD candidate in international law at the National University of Kyiv-Mohyla Academy. His research focuses on legal innovations in international humanitarian law, particularly in relation to new technologies and methods of warfare. He currently serves on the International Advisory Council of the Prosecutor General's Office of Ukraine, providing expertise on war crimes against the environment. In 2024, he co-coached the Kyiv-Mohyla Academy team that won the 47th Steldas International Law Moot Court competition, which is the main competition in international law in Europe. So Volodymyr's presentation today will concern Russia's environmental destruction in Ukraine under the Rome Statute, navigating accountability without an ecocide provision.
Please close the presentation.
Volodymyr, you would like to share the presentation?
No, I will present.
Nevertheless,
Yes.
that we can see the all.
Well, just like this, too close, like this. Is that better? No? Zoom.
If you have to return to Zoom, yes, stop sharing.
You think I'll show it?
I think
It's closed.
gone. Yes.
Volodymyr, the floor is yours, please.
Thank you so much for introducing and for giving the floor. And I'm very glad to join, and thank you very much for your already considerable time being here today. My topic relates to what is sometimes referred as legal gymnastics, when one should engage with provisions that do not perfectly match or fit within a specific situation. So, generally speaking, the legality of environmental destruction and environmental harm would be perfectly assessed through the lenses of an ecocide provision. However, the Rome Statute does not list ecocide as the fifth crime, and it does not have jurisdiction over it, so we need to succeed and proceed somehow without it. So in my today's presentation, I'll mainly try to cover two aspects. The first one would be what is still the framework for environmental protection within the international humanitarian law and Rome Statute. And the second one would be how can the Russian conduct against the environment fit within this current Rome Statute framework based on some examples from the full-scale aggression against Ukraine. So generally speaking, the environment historically received little attention in terms of IHL and international criminal law because they mainly were centered on the protection of persons and property during war, both within the Hague and Geneva law. These anthropocentric development of ICL delayed the recognition of the environment as a silent victim of war, I would say. Because if we look even at the main crimes within the Rome Statute, genocide, which may be said anthropocentric, but maybe even genus-centric, because the group of persons is the protected one, not the particular individuals, or crimes against humanity, or war crimes as well, they started all with some anthropocentric ideas borne in mind. Even the statutes of international criminal tribunals, ICTI, ICTR, etc., they have not included provisions which specifically addressed the protection of the environment. And the Rome Statute actually is the first one to name, at least, and to use the word environment in its statute. But I'll come to this later. I'll just make a reservation that indeed, that does not mean that the environment was not protected all these times. For instance, the directly targeting civilian objects during armed conflict would be unlawful. And here the environment as such is also part of these civilian objects category. So in this regard, the environment would be protected. However, most of the instances of the environmental harm and damage would usually form part of what we call collateral damage. in fact, any type of military operation or military activity would somehow negatively impact the environment. It may be an artillery shell, which would release some toxic gases into the air, or they would erode the ground when they are already inside the ground, or they may destroy vegetation. The airstrikes may lead to fires usually, but actually all of these, if they are purported with the military advantage and with targeting military objectives, they would rather not be illegal than not under international humanitarian law. Indeed, all of these may be actually unlawful from the viewpoint of jus ad bellum and the crime of aggression, but there are difficulties with jurisdiction with the ICC, and the ICC has no jurisdiction over the crime of aggression in the case of Ukraine and Russia's aggression against Ukraine. So with these examples of some collateral damage of the environment, it mainly underlines this inherent balance underpinning the sense of IHL, which is balancing military necessity with the humanitarian aspirations. This is actually the price we need to pay for the laws of war to be realistic and be acceptable by states, but also to be at least partly enforced and abided by. For instance, the shelling of military equipment within a forest, even if it causes some uncontrollable fires, would rather be seen as permissible under IHL. But still, there are some instances when the collateral damage or indirect damage, let's say, to the environment is of such a magnitude that it would be unlawful, even though the primary purpose of an attack, for instance, was to hit a military object or to weaken enemies' military forces. And now I would just categorize the environmental harm into 3 baskets. This is something which the ICC Office of the Prosecutor does in its draft policy on the environment. It says that first there is a crime which directly mentions the environment, which is Article 8.2b4 of the RAM Statute and relates to the excessive environmental damage. The second basket would be crimes committed by means of environmental damage. So, for instance, pollution of wells to cause killing of persons, right? That's the environment is used as a mean to incur damage. Or, for instance, attacking some chemical plants to spread the dangerous elements. It was the case with Azot chemical plant in Severodonetsk, which was targeted by Russian forces. Then there is a third basket, which is the crimes resulting in environmental damage. So not by the means, but just a crime which also resulted in environmental damage. This would mainly relate to carpet bombings, for instance, where the environment is not the primary target nor the primary mean of incurring damage, but it is still destroyed during such attacks and such military operations. And that may be the case of destructive bombing of Mariupol, which also caused significant environmental damage. Or, for instance, the theft of animals from Askania Nova Reserve, which was classified by the Ukrainian Office of the Prosecutor as the crime of pillage, right? So there are mostly different anthropocentric crimes like willful killing or willful causing serious injury to body or health, or destruction of property, pillage, or even starvation, which may qualify and may relate to the environmental damage as such. Within these crimes, actually, the environment would not receive as much attention, right? It would not be the protected object as such. But these assessment and taking into account this environmental damage could help, for instance, for the gravity assessment for the ICC, or, for instance, for the reparation processes, which is also a way forward of taking into account the environmental destruction during processes within international crimes liability. And I haven't mentioned here genocide, but actually genocide could also be perpetrated by means of environmental damage. And some of the examples which are provided are within literature are the Saddam Hussein's draining of marshlands in southern Iraq against some marsh Arabs. They were an indigenous community which their life was dependent upon the environment, and Saddam Hussein's viewed them as complicit in the enemies, and this is why they specifically drained the marshlands, which caused also which led also to the deportation of marsh Arabs from these areas. So these could be seen as the crime of genocide through the creating these types of environment where the group could not anymore survive, for instance. Or al-Bashir situation, which is not taken to the court, unfortunately, due to execution of the arrest warrant, but within the genocide charge, the prosecutor also highlighted that the intent was to poison sources of water, including communal wells, or to destroy water pumps, or to steal livestock, etc., as to purport this genocidal intent. It goes along with some other main charges as a willful killing of the group, but these environmental aspects are also taken into account. Here I would end with this overview of anthropocentric crimes, as we call them, relating to the environment, and turn my attention to this unique provision, but untested provision within the Rome Statute, which is Article 8.2b4. It's the first provision in the Statute of the International Tribunal, which mentions the environment, and it mainly prohibits an attack that may cause widespread, long-term, and severe environmental damage, but which would additionally be excessive compared to the military advantage. I would like to draw your attention actually to the high thresholds encompassed within this provision. First of all, these notions of widespread, long-term, and severe are cumulative, and they set really high thresholds in terms of territory. For instance, widespread relates to hundreds of kilometers squared, or long-term would refer to decades of damage, which would be hard to anticipate actually at the time when the crime is occurring, or when even the processes start in terms of issuing an arrest warrant or indicting a person. But also, I would like to draw your attention to this additional requirement of proportionality with the military advantage, right? Because this is actually what differs the Rome Statute provision from what is said in the additional protocols of the Geneva Conventions and in international humanitarian law as such, which forms a basis for the war crimes provisions. These actually divergence led to a discussion whether the provision of 8.2b4 is a step forward in terms of environmental protection or a step back. And my view and my short answer, I think, would be it is forward in terms of policy, but it is back in terms of law. And let me explain. Actually, this provision is inspired by Articles 35 and 55 of the Additional Protocol 1, which said that, and I will quote, that it is prohibited to employ methods or means of warfare which are intended or may be expected to cause widespread, long-term, and severe damage to the natural environment. Period. That's nothing about military advantage which could excuse or justify the widespread, long-term, and severe damage to the environment. If the damage reaches that threshold, the violation occurred. So this is an absolute prohibition of widespread, long-term, and severe damage. Instead, Rome Statute provision mixed up this provision with the proportionality requirement and the proportionality principle from the IHL. However, the proportionality requirement from Article 51 of the Additional Protocol, for instance, it does not mention the environment. It does not mention these high thresholds of widespread, long-term, and severe. It just stipulates that the damage to the civilian population or to the civilian objects, which is higher than the military objective pursued, would be unlawful, right? So one would wonder, why do the prosecutors need to prove these widespread, long-term, and severe damage if they could go with an easier option to prove just that the civilian objectives which were also which also incur damage because of the attack, and which also encompasses the environment, was higher than the military advantage anticipated, right? This is why I think in terms of policy, it is great that the Rome Statute incorporated the notion of the environment explicitly in its provisions, but in terms of law, it mixed two different provisions and increased the threshold so much that this provision is yet untested from when the Rome Statute became operative, and seems not to be tested in the near future as well. So just to conclude, I would say that there is still a possibility, maybe not with this specific article A2B4, which relates to the environment, but there is still the possibility to engage with the environmental damage through some other crimes, like the crime of pillage or the destruction of property, or even attacking civilian objects, right? But within the current framework and within this Article A2B4, which is seen as an alternative to the ecocide provision, so I think we're not to expect that some jurisdiction on this specific provision will occur in the near future. I hope it will be changed, and I hope that, for instance, some of the gravest environmental cases, like in Ukraine, the Kakhovka Dam destruction, could be tested throughout this Article A2B4 provision. But let's see how it unfolds. In any event, we still have some regular crimes which could cover and encompass the environmental damage done by Russia in its aggressive war against Ukraine. Thank you so much for the attention, and I'm glad to participate in the discussion further.
Thank you very much, Volodymyr. Thus far, we listened to, thank you for your insightful intervention. Thus far, we listened to presentations on different crimes which are being committed by Russia in Ukraine: genocide, sexual violence, cultural destruction, environmental destruction. They have been committed for more than 3 years. But our next presentation will be on the question of justice for these crimes, for international crimes and gross human rights violations in the peace negotiations between Ukraine and Russia and the potential future peace agreement. Just a few words about our next presenter, Maxim Vishchik. Maxim Vishchik works as a legal advisor with Global Rights Compliance Foundation and specializes in public international law with a focus on international humanitarian, criminal, and human rights law. In recent years, Maxim has been involved in various projects aimed at strengthening Ukraine's capacity to investigate and prosecute atrocity crimes, including mobile justice teams assisting current conflict-related investigations, and the MATRA Ukraine project, strengthening Ukraine's capacity to investigate and prosecute international crimes. Maxim is a PhD student and lecturer in international law and international human rights law at the National University of Kyiv-Mohyla Academy. Maxim, the floor is yours.
Thank you very much, Professor Antonovich, and good afternoon, dear colleagues. I am very happy to be here online and see so many familiar faces. That's a great pity that I cannot join offline, but we have what we have. And yeah, I'm happy to contribute with this concluding presentation. I'm grateful to my colleagues for a lot of forward-looking presentations and insights. Mine will be forward-looking, and it will be both hypothetical and realistic, because we never know. We've been in this realm of potential peace negotiations and potential so-called peace deal between Russia and Ukraine for several months now, since the Trump administration took power in the United States. And essentially, Russia doesn't care about accountability, except for it does. And Russia keeps its focus on accountability issues in Ukraine, including in the potential peace negotiations. In March 2022, when Ukrainian and Russian delegations met in Istanbul, Russia demanded, among other things, from Ukraine to withdraw both declarations recognizing jurisdiction of the International Criminal Court. Essentially, Russia wanted Ukraine to withdraw declarations in order for the ICC to terminate the exercise of jurisdiction over the crimes committed in Ukraine. In 2025, Russia returned back to Istanbul. Russia didn't talk about ICC anymore, but Russia set two main conditions. One of them was granting amnesty to, quote, so-called political prisoners and release, quote, so-called detained military and civilian individuals. And the second one was to waive any war reparation claims. Some people also claim that Russia or third parties, for example, the United States, also want to suspend or hold any international crimes prosecutions in Ukraine and beyond. So also to insert pressure on the Ukrainian government to terminate any proceedings related to atrocity crimes. So it brings us now into this realm of the potential negotiations between Russia and Ukraine, where we do know that accountability issues will arise and or are likely to arise. And before I move to 5 main pillars of what I consider necessary to address in this potential peace process, I will just briefly outline where we stand now. So we have 3 layers of accountability efforts: domestic, international, and the one related to reparations. If we talk about the domestic level, as my distinguished previous speakers noted, we have ongoing prosecutions of war crimes since 2014 at minimum, but especially since after 2022. Then domestic prosecutions of the crime of aggression, domestic investigations of the crime of genocide, and crimes against humanity, which were introduced after the Rome Statute was ratified last year, and now the Ukrainian government anticipates new proceedings to be opened. We also have a chunk of crimes related to national security, where people were detained, prosecuted, and then tried for example, treason or collaboration activities, and that is potentially what Russia means by political prisoners. On the international level, we obviously have the International Criminal Court with the investigation ongoing and 6 arrest warrants issued to date. We have the newly established Aggression Tribunal under the auspices of the Council of Europe. And we also have the International Court of Justice, which doesn't really relate to the atrocity crimes accountability, unfortunately, but still is an ongoing international proceeding. And we also have the third block of related to reparations. We have the Register of Damages for Ukraine and quite a limited capacity of the International Criminal Court's Victim Fund that can assist. So these are the 3 layers of accountability that we have to date. And these are the 3 layers that Russia is very much likely to target in whatever bargaining it has with the Ukrainian government or the United States and third parties. So to address any potential Russian demands, we have to keep in mind 5 main blocks of international law issues. The first one is, what is the nature of any potential peace deal between Russia and Ukraine, including its validity or invalidity under international law? The second one is the role of the principle of non-intervention and non-interference into domestic affairs of Ukraine. The third one is Ukraine's own sovereign obligations to prosecute certain types of conduct, particularly international crimes, as well as Ukraine's discretion to abandon certain prosecutions, for example, for the sake of amnesties. Then the fourth one is the role of International Criminal Court in maintaining further accountability efforts. And the last one is reparations and whether Ukraine can legitimately waive its right to obtain reparations for itself and its own citizens. I know it's quite overwhelming, these 5 blocks, but I want to address them briefly one by one to basically draw the framework in which we operate when dealing with the potential peace negotiations with Russia. The first umbrella block relates to the nature of the peace deal itself. And we have this fundamental provision in Article 52 of the Vienna Convention on the Law of Treaties, which also reflects customary international law, that says that any agreement concluded under the threat of use of force or under the use of force is a void agreement. The word void here is not used just accidentally. The voidness of the agreement entails that the agreement doesn't exist as a legal fact, full stop. The agreement is just legal fiction, it's just legal fake, and therefore it doesn't create any obligations for the victim state and any rights for the aggressor state. This means in basic terms that as long as Ukraine continues to be under the armed attack from Russia or threat of armed attack, any agreement concluded under this armed attack will be a void agreement and won't create any legal consequences. When I say armed attack, I don't just mean active hostilities. It isn't about active hostilities on the front lines. Even if active hostilities are no longer in place, but even if the inch or a meter of the Ukrainian territory is being occupied, this is qualified under public international law as an armed attack. Even if just 1 centimeter of your territory has been occupied, you have been under the continuous armed attack, even if you are not being shelled or attacked physically. That means that for as long as Russian troops are on the territory of Ukraine, Russia and Ukraine can negotiate on the ceasefire. Russia and Ukraine cannot negotiate on the full-fledged peace deal. This entails in turn that provisions of such a void agreement are inseparable. You cannot just take and cherry pick each of them and choose which of them is valid or invalid. It means that whatever is in there related to territory or related to political system or related to accountability will be a void provision. Therefore, whatever Ukraine consents to in terms of halting or suspending prosecutions domestically or internationally will be void. Politically, yes, Ukraine can be pressured to abide by that agreement, but legally it will mean that at any point of history, the Ukrainian government can go forward and say, yes, politically we did that because we were pressured, but legally we are entitled to non-compliance. So this is kind of an umbrella. Whatever Russia wants to see in that peace deal, if the peace deal in whole is invalid and void, then any accountability provisions in there won't matter legally. Politically they might, unfortunately, but legally they won't. The second issue relates to the principle of non-interference into domestic affairs of every state, one of the pillars of the modern world order and international law. Let's forget about the use of force. Let's say even if the peace agreement was valid, then the principle of non-interference can also invalidate any potential pressure put onto Ukraine on the accountability issues. The principle of non-intervention protects all the fields of life that belongs to the sovereign domain of every state, the so-called principle of domaine réservé. So whatever social issue belongs to the sovereign domain is untouchable from other states. That means that no state can coerce or pressure another state to change any social policy belonging to its sovereign domain. This sovereign domain includes, among other issues, prosecutions for a particular type of conduct. It is up to a sovereign state to decide what it prosecutes or not, whether it grants amnesty for something or not, how it forms its prosecutorial policy. So the principle of non-intervention will invalidate as well any demand from the Russian government for the Ukrainian government to hold international crimes prosecutions. Again, this is up to Ukraine as a sovereign to decide what conduct is prosecutable and what conduct belongs to the sovereign domain of a state. So even if peace deal was valid under international law, the principle of non-intervention will play a role in invalidating Russian claims. The third issue is not whether Russia would pressure Ukraine into successions in accountability issues, but whether Ukraine has a sovereign choice to provide such concessions. By that I mean, does Ukraine have a choice whether it prosecutes international crimes or not? The short answer is not really. So even if Russia pressures Ukraine into non-prosecution, then there is an important issue of Ukraine's own sovereign obligations. By that I mean that Ukraine doesn't really have a choice whether to prosecute international crimes or not, because it must. If you open the Genocide Convention, Articles 4 to 6, they are unequivocal and unconditional in imposing an obligation on the state to prosecute and try the manifestation of the crime of genocide. There are no exceptions. The state is just obliged, the state just must do it. The same relates to war crimes. Geneva Conventions and additional protocols there too don't leave any space for maneuver for a state. A state must search for persons responsible for that kind of crimes, and a state must try them according to its domestic legislations. So in relation to war crimes and the crime of genocide, Ukraine doesn't have a choice whether it can or cannot prosecute them, it must. In relation to the crimes against humanity, the situation is a bit more complex because there is no conventional obligation, there is no convention on crimes against humanity which would entail obligation to prosecute. Many scholars do argue that there is a customary obligation to do so, but this position is still a bit unsettled. So at least in relation to genocide and war crimes, there is an obligation to prosecute. And the same relates to the question of amnesties. If, for example, Ukraine decides to bargain with Russia about potential collaborators that assisted Russia in its attack on the Ukrainian soil, then Ukraine has a sovereign maneuver to decide whether it wants to surrender these persons to Russia or provide amnesties to them. The same doesn't apply to international crimes. As Professor Koval already touched upon this topic, there is no choice for Ukraine whether to grant amnesties for genocide and crimes and war crimes or not, because Ukraine simply cannot. As I said, the provisions of the Genocide Convention, the Geneva Conventions and additional protocols are unequivocal. You cannot grant amnesties. There is no exception for your obligation to prosecute. Again, unfortunately, in relation to the crimes against humanity, the picture is a bit more complicated. The state practice and opinion juris are not quite uniform to say that there is a rule of customary international law ruling out the possibility of amnesties. Many domestic and international courts said that, and scholars said that there is a moving tendency in that direction, that there is an emergent obligation to prosecute and obligation not to grant amnesties, but the state of international law is not there to say unequivocally. But to conclude this third block, even if Russia pressures Ukraine into that, it's not the matter of Ukraine's choice. Ukraine also has a legal obligation, apart from political realities, to prosecute this kind of conduct. The fourth issue I wanted to address relates to the role of international courts in the current accountability processes, and by that I mean the ICC. So in March 2022, the Russian delegation told the Ukrainian delegation in Istanbul that Ukraine must withdraw the two declarations it issued to accept the ICC's jurisdiction in order to conduct any further negotiations. The Ukrainian government obviously refused. But let's imagine if Ukraine had decided to do so in 2022, would it have deprived the ICC of its jurisdiction? It is certain that it wouldn't have done so for the past events since 2014 before 2022, because the basic rule is once the state grants the jurisdiction to the International Criminal Court, the deal is done. The state cannot retroactively just undo the recognition of the jurisdiction by the International Criminal Court. So let's imagine 2022, if Ukraine had done so, then there are two polar positions. Some people may argue that because recognition of the jurisdiction of the ICC is a unilateral act of a state, then a state potentially can, by another unilateral act, undo the previous declaration and stop the jurisdiction on a particular date. But again, it will only apply proactively, not retroactively. So between 2014 and 2022, the ICC would have in any case had jurisdiction, even if Ukraine withdrew the declarations. At the same time, there is no provision in the Rome Statute providing for such an opportunity. So another room for argument is once you granted the jurisdiction to the ICC by the way of declaration, you cannot simply undo the jurisdiction because there is no provision allowing you to do so. But it doesn't matter really, because in 2024, Ukraine ratified the Rome Statute, which created an independent autonomous ground for jurisdiction. So after 2024, apart from declarations, there is a jurisdiction by way of their ratification, and therefore another ground of jurisdiction started to apply. So now, even if Russia wants to pressure Ukraine to force the ICC into abandonment of the Ukrainian case, Russia doesn't really have instruments. The only instrument is for Ukraine to withdraw from the Rome Statute, which according to Article 127 of the Rome Statute will mean that Ukraine will do so, then a year will pass by, and only then the Rome Statute will stop to apply jurisdiction will stop to apply in relation to Ukraine, but will still apply in relation to 2014-2025. So whatever card Russia wants to play, there is no way that ICC would abandon jurisdiction in relation to the past 11 years. So whatever Russia wants to do and however Russia wants to pressure Ukraine into further negotiations, the jurisdiction of the ICC over international crimes is secured. And the final question, one of the most interesting to me, is the question of reparations. So if you open the articles on responsibility of states on for international wrongful acts, the so-called RCEVA, you can read a basic international principle that every international wrongful act entails international responsibility of the state and an obligation to provide reparations in the form of restitution, compensation, or satisfaction. Accordingly, Russia's act of aggression and ensuing international crimes raise an obligation of Russia to provide reparations for every act done. For that obligation, Russia doesn't need a judicial pronouncement. Russia doesn't need an international court decision. The obligation to provide reparations arises per se because of the wrongful conduct. But can Russia demand from Ukraine to withdraw its claims for reparations forever? Article 45 of RCEVA technically says that the state loses its right to invoke responsibility if it waives the claim for reparations. So if Ukraine comes and validly, which is an important word, validly says, okay, Russia, we don't have any other claims to you, then technically under Article 45 of RCEVA, Ukraine will lose the right to receive reparations. But the word validly here is important. The word validly indicates that there should be no coercion by the way of use of force or threat thereof. So again, we come back to point one. If there is a threat or use of force that continues, Ukraine cannot validly waive its right to reparation. But even if there was no use of force or threat thereof, there is an interesting discussion, and I will be honest with you, I don't have an answer to that. I feel like I need several weeks to research that. Can a state really abandon reparations for its citizens if they cannot find any other way to get them? Russia is no longer a party to the Council of Europe and European Convention on Human Rights, so Ukrainian citizens don't have a choice. They don't have any other option or venue to go for reparations, obtain reparations from Russia. And an interesting argument can arise from international human rights law. One may claim that international human rights law obliges a state to fight for its citizens for the reparations for gross human rights violations and international crimes, because otherwise a state would leave its own population abandoned without reparations for the most serious international crimes. A parallel to this argument, and this is my last point, can be found in the Ilyashku versus Moldova and Russia judgment from the ECHR and the subsequent judgments, where the ECHR said, even if state's territory is occupied, a state doesn't lose all its human rights obligations in front of its population in occupied territories. A state still has a residual obligation to fight for its own population, diplomatically or politically. So we can make an argument saying that international human rights law, even if not obliges, at least encourages a state to continue making claims for reparations for its defenseless citizens that don't have any venue to go to. So these are the 5 points I wanted to make to just outline the framework that we are in. And while the framework may seem pessimistic, I'm quite optimistic because international law actually holds Ukrainians back. And however strongly Russia wants to force Ukraine into concessions on the accountability issues, all these concessions will never pass the international law test. So accountability is a long road, and sometimes it may seem that we don't see the light in the end of the tunnel, but that's okay as long as we keep moving. So regardless of how hard Russia tries, for as long as the international legal order exists in its current form, Ukraine's back is secured, probably not immediately, but at least in a matter of 5, 10, 15 years, Ukraine will always be entitled to say, yes, politically we conceded, just because we didn't have any other choice, we are pressured to, but legally, we know that we are entitled not to comply with the Russia's draconian demands. I'll stop here. Thank you, and I'll be happy to take any questions.
Thank you very much, Maxim. It's for your such logical conclusion of our today's roundtable. We started with the issue of amnesty versus justice, and you concluded today's roundtable with the same issue. And as I understood, these 5 points which you have just analyzed, they can not be included into peace agreement, right? No negotiation concerning these 5 points which you have just enumerated, right? No negotiations on the issues which you have enumerated. Thank you very much. I understand that we ran out of our time and we have to wrap up. But on the other hand, I promise to give just a minute for each presenter for concluding observations if you wish to. If not, I don't see the hands with questions. No hands raised. Do you have to say anything in conclusion? There was a question from Ina, actually. Can the Genocide Convention be amended? Or how can it be? There is high time to amend it, but we understand that it's unrealistic to amend it.
I can make a short statement.
Yeah.
Yeah, I think there was actually an attempt to regulate genocide newly in the Rome Convention. But this failed, so one took not a step back, but took the old historic drafts and clauses. So and I think it also doesn't help us here because we have to live with what we have here. Yeah. And I think at the end, if we argue properly, and thank you, Maxim, that you really shifted your view from the political argument to the legal argument. And legal arguments always take a long time, and they take a court proceedings. So, and this is my concluding remark. Thank you for the great insights on sexual harassment, on environmental, on cultural, and also on the peace treaties, which I haven't followed up yet in that context. And from my point of view, everything what was discussed here and also is discussed in other contexts is right in a way. But we have to do the next step, as Maxime did it. We have to be legally effective. And this is a much tougher step to take because it also takes considerations with procedure, taking into account the other positions in that context. And from there, I really thank you for the opportunity to give my contribution here.
Thank you very much. Natalia also wants to make a concluding observation.
Yeah, answering the question and moving to concluding observation. When it comes to genocide convention, maybe it would be beneficial to add the notion of cultural genocide. And I know that certain NGOs are advocating for this because it was originally also in the thoughts of Raphael Lemkin, but it was not consented by the states parties which concluded the genocide convention. And so when it comes to answering the question, and then the general observation not relating to culture, but to our overall discussion from the beginning to the end, the obvious elephant in the room is indeed the need to reconcile international politics and international law. And I think this is the remaining challenge to all of us as international lawyers, how to bring more law into the politics in order not to need to make this difference between the politics and law often, and then kind of explaining why this politics is actually contradictory to what the legal norms prescribe.
Thank you. Yulia?
Also, concluding remarks and also comment I wanted to say after the presentation of Professor Weber, and it concerns basically the possibility for or the need to amend the Genocide Convention. In my opinion, amendment of the Genocide Convention would be too complicated, but what we need is a reinterpretation. And for example, the idea of the narrow definition of national groups. As you were talking about it, I had this idea, this analogy that probably this understanding was formed during when this internal conflicts in mind. So it was applied to more like situations of internal armed conflict. And analogy I had in mind is a concept of transitional justice, which also developed as a concept which is applied in internal armed conflicts, and now it's been redefined and spread to international armed conflicts and different paradigmatic situations. So in terms of genocide, we also have quite often paradigmatic situations, but not Genocide Convention and no definition or understanding. So we need to reinterpret this Genocide Convention. And my conclusion from today's roundtable would be that probably I want to focus on the fact that we have international armed conflict here, and the rules which are applied in international armed conflict are quite different. So we need to reconsider traditional concepts of international criminal law and accountability.
Thank you very much. And Maxime has also raised his hand.
Yeah, I'll briefly also answer the question and conclude then. I've been researching the crime of genocide for the last 3 years for my PhD thesis, and I am sick of it. I'll be honest with you, what I tell my students is, if I was about ever to be accused of an international crime, I would never want it to be genocide, because genocide is so vague and unsettled in the legal elements, many of them. But my reflection is, in the last 3 years, I've observed several positions on the spectrum. One position that is conservative and that belongs primarily, started from the article that Professor Shabas, that Professor Weber cited, wrote in September 2022, essentially saying that it is not genocide in Ukraine because the numbers are not there. And so I've observed it a lot in the last several years. People saying, look, Ukraine is bad, but have you seen Srebrenica? Ukraine is obviously bloody, but it is not as bloody as Bosnia. Ukraine is bloody, but not as bloody as Rwanda, not as bloody as Holocaust. And this is essentially a wrong logic, because you shouldn't be taking templates of other genocide and putting them on other contexts. Among all the international crimes, I feel like genocide is the most contextual crime. Genocide is the most context-sensitive crime. So this is one side of the spectrum that is inherently wrong. Like you can get inspiration from the previous context. You cannot measure the Ukrainian situation by them. On the different side of the spectrum are the calls to penalize more, criminalize more, protect more groups, include more underlying acts, also include cultural genocide, for example. I'm not sure I support that either, because to me, the Genocide Convention was born through a lot of pain in that window of opportunity. So to me, you cannot reshape the Genocide Convention and the concept of genocide as it stands legally. But I fully agree with Yulia that what we need to do is to reinterpret several elements of the crime of genocide. Among them, the definition of protected groups, among them, the definition of the group in whole and in part, among them, the notion of destruction and its limits. So we cannot change the convention, but we can definitely influence the interpretation to make it more close to the realities, to move it far away from the previous context, looking at them as templates for the crime. And I feel like this is my concluding remark. I feel like Ukraine has a lot of potential to do that. Not to create the law. I hate when people talk about recreating the law or inspiration to make new law. Sometimes the law is where it is, but sometimes inspirations that we produce domestically or internationally do inspire subsequent contexts. So yeah, this is my remark.
Thank you very much. And this is actually what Yugoslavia Tribunal, Rwandan Tribunal were doing, reinterpreting, and ICC is doing. I see the hand of Ina. Ina, please, very shortly.
Yeah, I'm very briefly. Thank you very much again for this possibility to my question. My question regarding about possible peace agreement with Russian Federation. How can Ukraine make sure that justice for war crimes, genocide, sexual violence, culture, environmental destruction is not be ignored in future, this peace agreement, because we have a lot of case and about our deportation of our child and sexual violence and other different significant things. It's very important, I think, to open this question, and thank you very much for advance. Yeah.
Thank you, Ina, for being that active today. I understand, and we all understand, that these are rhetorical questions, which will be answered when the process starts, when the peace negotiations start. At this point, I would like to thank our esteemed presenters for the very thought-provoking and insightful presentations. I would like to thank, first of all, to the Ukrainian Free University and the staff of Ukrainian Free University for making our roundtable possible in these premises of the Ukrainian Free University, which are like museum. We have so many sculptures of Grigory Kruk, paintings by very famous painters. So we feel like in museum here. Thank you, Rector Ditkovska and Dr. Tutenko and now the people who are not here but were with us and helped us with all this. I would also like to thank to the audience, both online and here in the room, for being that patient. And I'm sorry I failed as a timekeeper today, but I think that as a moderator, I was not that bad as a timekeeper. So thank you, everybody. Thank you. I see another hand by Irina Knapfel. Irina, you raised your hands?
No, it was applause.
Yeah.
Okay.
So with this, I thank you, the audience. I'm sorry you are not here with us. Otherwise, you will go with us to the next room and we will continue in informal atmosphere our discussion. At the real round table. This table was not round, square round table, but then we will continue and I invite everybody and thank you once again. Bye and see you. Thank you, my.
Thank you very much. Yeah.
Thank you. Thank you.
Bye.
Thank you very much. Bye-bye.
Bye-bye.
of the,
I know. You stop here, not
Yes.
not end,
and then
and then end. Mhm.